Hey everyone, it's Shawn. Welcome. Thanks for tuning in for a special edition of the McBride Attorneys Law Show. Today we're going to be talking about the role of the courts in lawmaking and the law system. I've been out there, obviously a lot of you know I'm very active in a lot of communities about freedom issues. I run the American Freedom Information Center Facebook group and the nonprofit we're founding. So I'm constantly engaging with people about freedom issues. And one thing that I've been seeing on a recurring basis is there's a lot of confusion about the role of the courts in the system and how the courts work. What do they do? What is their role? So I wanted to spend a little time today with you, and feel free to comment here live if you're watching live. Feel free to comment on the replay if you're watching on the replay with questions. We'll do more videos if we have to. But what I really wanted to do today is to dive in and give you an idea from a lawyer's point of view. I am a practicing lawyer, been through law school, passed the bar exam in multiple states, about what the court system does, so that we have a better feel for what we can expect from the courts, what they should be doing, what they shouldn't do, what cases mean, because there's a lot of confusion out there in the advocate world about what these things do and what they mean. So we'll be jumping in it. Just a standard reminder, this is not legal advice. This is just a discussion of a very broad level. If you need legal advice, consult your attorney. This is just an open, broad discussion of what we have going on here. So let's jump into it. The system in the U.S. is based on having three branches that are in theory co-equal, right? We have the executive branch, that's your governor or your president. We have the legislative branch, that's the people that write the laws. And then we have the judicial branch. So three branches, and that's the way they're laid out in the U.S. Constitution, right? 1, 2, 3. And they each have separate powers. So in theory, the executive, and I know it's a review for a lot of you, but it's fundamental to what we're talking about. So bear with me. We'll get into some deeper stuff here in a minute. The executive branch executes the laws, right? They make sure the laws happen. They have the administrative bodies underneath of them. They do whatever they have to do to make sure the laws happen. They also are in charge of prosecution, other issues. So the executive branch makes the laws happen. The legislative branch writes the laws. And in theory, the judicial branch, which is what we're focused on today, is going to interpret the laws. Their job is to look at the laws and say, what do the laws mean? And you might say, well, why do we need that? Because the laws are written. Well, you need somebody to connect the dots. The legislature is going to write the laws. Somebody's got to go back and look at the laws, make sure they make sense, make sure they work, and then use those laws in actual application, right? Somebody might get tried for a criminal trial, right? Somebody might not be wearing their mask, and there might be a trial, and the judicial system has to look at the law and say, what does the law say? Did this person violate the law, right? That's the fundamental thing. And that's the very simple level of the judicial system, is the trial court. Facts, law, right? And the trial court's largely attached to two. These are the facts of the case. This is the law that we interpret it to be as the judicial system, and we connect the two. And so, who wins the civil case over a contract broken between two businesses? Does somebody go to jail for not wearing their mask? All of this is the simple part of the trial court. And that's the part that most people are familiar with. And so that's definitely one role. But the other role of the court system is the higher level courts. If you look at the way courts are typically organized in a given state or in the U.S. system, it's usually a pyramid. State Supreme Court at the top, intermediate courts in the middle. These are courts of appeal, usually called something to that effect, circuit courts in the federal system. And then you have the trial courts. District courts, you'll call them in the federal system, right? So you have trial courts answering to appellate courts, answering to Supreme Court. And that's typically the way it goes. If you don't like what the trial court did and you think they made an error, then you go to the appellate court, the middle court. And then if you don't like what the middle court did, then you go to the Supreme Court. This is on the state and the federal level. On the state level, too, you can also go your state Supreme Court. And if there's a federal issue, a federal constitutional protection, you could potentially flip to the U.S. Supreme Court. So, assuming you have that three-level system in your state, boom, 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 you could actually have four different courts involved as you appeal a case, right? Go from your trial court to your appellate court to your Supreme Court in your state to the federal Supreme Court. 4 different times you're going to have to try this and fight over the law if it's a federal constitutional issue, potentially. So let's jump into that. So the court's job is to apply the meaning of law. But what do the laws mean? Well, who says what the laws mean? That's really where the appellate and the higher level courts come in. The trial courts usually don't want to get into deep issues of interpretation. They like more routine type issues. Bring in a case, they know what the law is, they have their guides, and bam, they apply this type of trial. They look at the guide and they come out with an outcome. Boom, 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 boom. Very procedural in the trial court. Trial courts usually are more focused on facts than development of the law. The appellate courts above the trial courts are usually more developed on the law and less on the facts. All the facts get tried at the trial court. The facts are usually not tried, and there are some exceptions at the higher level courts. U.S. Supreme Court actually will have some trials, believe it or not, under the U.S. Constitution. States versus states, et cetera, can actually go directly to the U.S. Supreme Court. They'll actually have a trial, but that's unusual. Usually, trial level courts are applying facts. Intermediate courts are applying laws, and they deal with the facts at hand. So a lot of people have said, hey, I don't need to look at Jacobson versus Massachusetts, a U.S. Supreme Court case, because it only applies to the facts in that particular case. And the answer to that is yes and no. Yes, every time courts are proceeding through the system, the court is only dealing with that one particular case at that one particular time. But whatever they do, other people will be looking at that in the future. So if Jacobson versus Massachusetts comes through and the U.S. Supreme Court says, take your vaccine or pay a fine, other people are looking at that generally to see what it means, because they want to know what the Supreme Court would do the next time. Not every case goes to the Supreme Court, right? They're busy. They accept the cases they want. You don't have a guaranteed avenue to get to the U.S. Supreme Court. They don't have to hear your case. They only periodically get heard. So these lower level courts are constantly looking at what the higher level courts have done in the past and saying, what would they do if they had my facts right now? And you'll see that a lot. The judges are making guesses of what the highest level courts would do, which is why everybody talks in terms of U.S. Supreme Court opinions if there's one on point. Because if you have a U.S. Supreme Court case, typically everybody's going to be bound to it. The federal courts are going to be bound to do what they think the U.S. Supreme Court would do. And then your state courts, to the extent those issues are federal issues, federal constitutional protections that apply through the state, they're also going to apply to the state. That's why there's so much attention on U.S. Supreme Court cases, because they give us very clear guidance on what the highest court thinks. So that's why. And yes, they only make a decision based on those particular facts, but people try to extrapolate them out, guessing what the Supreme Court will do in similar cases, which is why those Supreme Court cases become so powerful, because they look at the facts of that one case, that is the decision, and then everybody has to extrapolate. The federal agencies, the state agencies, the other courts, everybody extrapolates. So there's a lot of extrapolation off of a U.S. Supreme Court case or a federal appellate case. So yes, it's only applicable exactly to that one fact, but it's used over and over again. So like when a Jacobson case comes down in 1905, Jacobson versus Massachusetts, 115 years later, people are still looking back at that because there hasn't been another case with similar facts that have made it to the U.S. Supreme Court. So everybody has to keep going back to that and guess what the U.S. Supreme Court would do. Occasionally, what the Supreme Court will do is take a case with similar facts to one they've had in the past, and then they'll update their reasoning. So occasionally we get fresh analysis, but usually we're looking backwards 10 years, 15 years, 20 years old for U.S. Supreme Court cases. And all the courts typically want to do what they call follow precedent. You want to do what you've done in the past. So once a court lays down the law, says how they interpret the law, typically everybody's going to want to follow that same interpretation and be consistent over time. They don't want to keep changing their outcomes. So once Jacobson's decided, courts are going to want to keep doing things consistent with Jacobson until the U.S. Supreme Court comes in and changes it. Every once in a while, you do have a case overturned. That's what they'll call it. They'll actually change the reasoning. So new facts, new circumstances, new era, new laws. They'll actually change the reasoning. But typically, the courts keep doing what they've done in the past. So lower level courts keep eyeballing the higher level courts of what they've done in the past, and they're trying to guess what a highest level court would do if it got appealed all the way up there. And then the middle courts are kind of filling in the gaps, right? There's a lot of gaps. The U.S. Supreme Court hasn't tried every law. They haven't answered every question. So if you can't get there, then you have the appellate courts. And the appellate courts will usually fill in the gaps. They give their best guess on what to keep doing with the issues. And usually you'll see there's what we call sometimes the conflict between the circuits. You'll have appellate courts in one circuit will do one thing, appellate courts in another circuit will do another thing. And so you have uncertainty. And that's a case where the U.S. Supreme Court often will step in, is when you start seeing 2, 3, 4 of those middle level courts in the federal system start disagreeing with each other, then it'll jump in. So we got to always remember, we're looking to what has happened in the past, and we're using that precedent. And new cases are tried guessing based on what the court has done with old cases. And that's what you keep doing, right? Every day, new cases keep coming into the court system. Court system doesn't want to have to look at every case as a brand new case. So even though all the old cases only dealt with the facts of that old case, the court says for certainty purposes and to avoid reworking and reinventing the wheel every time there's a case, we see what we did in the past. And we start kind of with the highest, then the lowest, right? So if there's a Supreme Court case on point, federal or state, we're going to go to that first because that's going to give us a lot of guidance. And we think that's pretty certain. And then go to those middle level courts if we have to, right? So you work top down. Courts are not supposed to change the law. The idea being, once the law is set, once they've interpreted the law, so let's say the law is unclear, or there's a question whether a law is constitutional, or whether part of a law needs to be reformed due to the Constitution, which is what Jacobson was, right? They said there's a state law, and Jacobson went to the Massachusetts court, eventually the Supreme Court, argued and said, this law isn't constitutional. And the Supreme Court came down and said, yes, it is constitutional. Right? That is what the court does. It interprets the law. It says, does this law work? Is it clear? Is it vague? There's a lot of protections we have under the Constitution. We won't get into those today, but if you're interested, drop me a comment. We can try to pick that up on a future episode of the McBride Attorneys Law Show here on YouTube. Make sure you're subscribed and ring the bell for notifications, by the way, for my channel. In theory, the court system is supposed to work independently of the judicial and legislative branches, right? So those two are doing their thing. The legislature's writing the laws, the executive's executing the laws, and the court system's there as to check. If they're not doing it the right way, the court system's going to come in and say, you can't do it that way, right? We're going to be we're the judge, right? I mean, that's literally it. The court system, we're the judge. We're saying it's not fair, it's out of bounds, it's not right. So you have to understand that the court system's going to jump in periodically and say, we don't like the way things are doing. When there's a case, right? You got to bring a case. There's got to be an actual issue. The court just doesn't jump in and say, we don't like how things are going. There has to be actual litigation, but there should be this independence. And the other thing we have to keep in mind, particularly when we get into very sensitive issues, is the court does often have a doctrine of political questions. Often people will want to bring an issue to the court, and the court will sidestep it by saying it's a political question. So if it's clear that the power is vested in the legislature, or it's clear it's vested in the executive, the court usually likes to sidestep it by saying it's a political question. So you'll see sometimes they'll come in there and people won't like the way a law is, or they won't like the way a law works. But if they think the law was enacted lawfully, the courts will often sidestep it and say it's a political question. Go back to your legislature, go back to your executive. So we got to keep this in mind. The court system only does so much. Their precedents are important because they tell us what they're going to do with the next case of law, because that's really where the rubber hits the road, right? The law is written on the books. That's the legislature. The executive's enforcing it through the police, etc. That's the enforcement. But where those two come together is in the court system, right? Whether that law will be applied and whether people actually go to jail, whether people actually be fined, whether people actually lose money on contracts or whatever, all that happens in the judicial system. So what the courts say matters, and we've got to look at their cases because they look at what they've done in the past. That's why it's so important, and that's why we reference old cases, because yes, they only apply to that facts that one case, but the principles are usually brought through in the future cases. Love your comments, folks. Glad you're here. We'll do another one of these. I want to hear what questions you have. I'll be monitoring and seeing what issues are there. Come join me over the American Freedom Information Center Facebook group. Make sure you get on our mailing list if you're interested in freedom issues, especially about American stuff. And then make sure you subscribe to McBride Attorneys Law Show on YouTube. Looking forward to your comments, folks. Thanks for being here today. I'll